Hello students, welcome to EPG Patashala. My name is Professor Y.S.R. Murthy. I am the Executive Director, Center for Human Rights Studies, OP Jindal Global University. In paper 13, we take up the national mechanisms for the protection and promotion and enforcement of human rights. Under module 2, today we take up the origin and evolution of public interest litigation. If you recall, in the last module, that is module 1, we covered various elements of a national protection system. We learnt about the role of legislature, executive, judiciary, National Human Rights Commission and the civil society. Today, we are going to focus on the role of judiciary and in particular the public interest litigation. At the end of this module, you should be in a position to appreciate 1. What is this public interest litigation all about? 2. The constitutional basis for PIL. 3. What are the characteristic features of PIL? 4. What are the achievements and critique of PIL? Public interest litigation has a great role in a democracy. It is a useful tool to secure justice in the society. First, used to describe the practice of lawyers moving for social change through court orders in America. It basically stands for legal action initiated in a court of law for furthering public interest. PIL played a major role in the securing of human rights. It involves judicial innovation. It involves creativity and activism on the part of Supreme Court. In fact, the Supreme Court crafted new strategies to further human rights. It evolved new remedies to secure human rights and advance and protect prison conditions, neglected children, bonded labor, environment, etc. Students, now that you have been exposed to the concept of public interest litigation, it's very important to understand what one of the foremost proponents of PIL has said about it. In the case of S.P. Gupta versus Union of India, Justice P.N. Bhagavati articulated the concept of PIL. In that judgment, the court said, where a legal wrong or a legal injury is caused to a person or to a class of persons by reason of violation of any constitutional or legal right, such person or class of person by reason of poverty, helplessness or disability or socially or economically disadvantaged position is unable to approach the court for relief, any member of public can maintain an application for appropriate direction, order or writ in the High Court or Supreme Court and seek judicial redress for the legal wrong or legal injury caused. Now that you have got a full understanding of what the public interest litigation is all about, let us now turn our attention to the constitutional basis for PIL. It can be found in the expansive interpretation of Article 21 dealing with right to life and personal liberty, read along with Article 14 dealing with right to equality and Article 19 guaranteeing freedom of speech and a series of other rights. In Maneka Gandhi versus Union of India, the Supreme Court interpreted Article 21 and in an innovative way and took the view that right to life will include all those aspects of life which combine to make human life meaningful, complete and worth living. In addition to Article 21, the court also relied on Article 14, which asserts the equality before the law, and Article 19, which safeguards the freedom of speech, association, assembly, the right to move and reside within the territory of India, and to practice any trade or profession. Part 3 of the Constitution deals with the fundamental rights, while Part 4 covers the directive principles of state policy. The directive principles cover the socio-economic obligations which the state must keep in view while framing legislations and policies. And in the constitutional scheme of things, anybody whose rights are violated can move the Supreme Court of India under Article 32 of the Constitution or any High Court under Article 226. The traditional rule of Locus Standi states that a person whose right is infringed alone can file a petition. In other words, no one else on his behalf can move a court of law. This has been substantially modified through a process of judicial activism in PIL. For instance, Justice Krishna Iyer, in the case of Municipal Council Ratlam versus Vardi Chand, relaxed the rule of Locus Standi, and one can see a number of other examples of such relaxation. One of the cases being S.P. Gupta versus Union of India. In the PIL, the rules for Locus Standi have been relaxed, enabling any public-spirited citizen or a non-governmental organization to approach the court for a public cause by filing a petition. However, in criminal and service matters, this has not been liberalized, and the court held that only those who are affected alone can move and have standing in such cases. The Supreme Court further observed that public interest litigation cannot be maintained by meddlesome interloper or a busybody, wayfarers or officious interveners having no public interest except for personal gain, either for themselves or for the gain of publicity. There are three aspects of Locus Standi which need to be reviewed. First, remedial nature of PIL. It departs from the traditional Locus Standi rules. It indirectly incorporated principles enshrined in Part 4 of the Constitution of India into Part 3 of the Constitution. Secondly, we need to remember that there is representative standing. It can be seen as a creative expansion of the well-accepted standing exception, which allows a third party to file a habeas corpus petition on the ground that the injured party cannot approach the court himself. Thirdly, there is citizen standing. For instance, the doctrine of citizen standing marks a significant expansion of the court's rule from protector of individual rights to guardian of the rule of law wherever threatened by official lawlessness. Under PIL, one can see a major deviation from the procedural rules of litigation. They extend to the form and manner of filing a writ petition, appointment of commissions for carrying out investigation and giving a report to the court, and appointment of lawyers as Amicus Curiae to assist the court. The Apex Court kept in view the need to fashion new remedies and new strategies, and which can be seen in the public interest litigation. Public interest petition is filed in the same manner as a writ petition is filed. Also, an advance copy of the petition has to be served on the each respondent, that is opposite party, and this proof of service has to be affixed on the petition. Proceedings in the public interest litigation commence and carry on in the same manner as other cases. However, in between the proceedings, if the judge feels that he may appoint a commissioner to inspect allegations like pollution being caused, trees being cut, sewer problems, etc. After filing of replies by opposite party or rejoinder by the petitioner, final hearing takes place and the judge gives his final decision. A PIL petition can be filed against a state or central government, municipal authorities, but not against any private party. In this context, it's important to remember the definition of state as given under Article 12 of the Constitution of India. In Electricity Board Rajasthan versus Mohanlal, the Supreme Court held that other authorities would include all authorities created by the Constitution of India or statute on whom powers are conferred by law. However, private party can be included in the PIL as respondent after making concerned state authority a party. But a PIL cannot be filed against the private party alone. As you can see from the picture given on the screen, the apex court entertained postcards such as these and given redress to victims of human rights violations. Similarly, people have approached the court through telegrams or letters which eased access to the court. It is known as epistolary jurisdiction. Examples are mentioned on the screen. Now that we have seen the principle of locus standi, you will appreciate that under PIL, the principle of standing has been relaxed. So, public interest litigation allows any member of public acting in a bona fide manner to articulate the cause of the victims of human rights violations. One can invoke court's jurisdiction just by writing a letter or sending a telegram. This is called epistolary jurisdiction. Only a person acting bona fide and having sufficient interest in the proceedings of PIL has a locus standi and can approach the court on behalf of the poor and the needy and whose fundamental rights have been violated and seek redress from the court. But this PIL is not available to a person who is acting for personal gain or private interests or profit or political motive or any other consideration as laid down by the higher judiciary. PIL proceedings involve new forms of fact-finding such as appointment of commissions of inquiry and handing over the investigation to the National Human Rights Commission or Central Bureau of Investigation. The court has taken the help of journalists, lawyers, district judges, bureaucrats and expert bodies for ascertaining the facts alleged in the PIL proceedings. The public interest litigation differs significantly from the traditional adversarial system. Here, the court, the parties and their lawyers are expected to participate in resolution of a given public problem. It becomes a cooperative and collaborative effort for the purpose of making human rights meaningful for the weaker sections of the community. As you can see from the screen, Amicus Curiae is a friend of the court who is appointed by the court in a particular case to assist the proceedings. A PIL petitioner is appointed by the court to focus attention on the matter. The person so appointed has no personal stake. In this case, the court expects that person to be conscious of his or her obligation to the case being examined and expects him to conduct himself or herself accordingly in the proper resolution of the case. That person cannot withdraw from the petition on their own free will. The court may take over the conduct of the matter if it feels that, in the interests of justice, that issue should be decided irrespective of the wishes of the petitioner. The lawyers aiding the courts in such situations are called Amicus Curiae. Senior advocates of Supreme Court have assisted as Amicus Curiae in several cases. Another important characteristic of the new remedies fashioned or crafted by the courts in PIL cases is the appointment of commissioner. The court appoints commissioners to help the PIL petitioners in cases where there is lack of access to information. For instance, in the case of right to food filed by People's Union for Civil Liberties, the Supreme Court appointed commissioners. Initially, Mr. Yashar Sankaran was a commissioner, and then he was followed by Mr. Harsh Mandar, who acted as a commissioner on behalf of the Supreme Court of India and submitted reports from time to time to the Apex Court. The Apex Court has appointed district judges, journalists, lawyers, mental health professionals, bureaucrats, etc. as commissioners in PIL cases. In the case of Indian Council for Environmental Legal Action versus Union of India, which is basically a case involving pollution, the Apex Court appointed National Environmental Engineering Research Institute, NERI, as an expert body to study the situation of groundwater soil pollution. The power to appoint commissioners in matters of civil nature is also found in Order 26 of the Civil Procedure Code and Order are on the Supreme Court rules. The powers under Article 32 and Article 142 are wide enough to permit such a course of action in any matter before the Supreme Court. The commissioners help in proposing remedial relief and monitor its implementation. So students, at this stage, it's important to understand what matters can be taken up as a public interest litigation and what cannot be taken up as a PIL case. The Supreme Court issued guidelines from time to time. In 1988, it issued a notification stating that matters concerning bonded labor, neglected children, petitions from prisoners, petitions against the police, atrocities on women, children, scheduled castes and scheduled tribes, etc. will be entertained as a public interest litigation. At the same time, the Supreme Court clarified that landlord-tenant disputes, service matters and admission to medical and other educational institutions will not be entertained as public interest litigation. Students, at this stage, it's very important to ponder on how the public interest litigation impacted on the poor, disenfranchised, dispossessed and marginalized and oppressed sections of the people. For instance, Husainara cartoon versus State of Bihar was the first reported case of PIL seeking relief to the under trial prisoners languishing in jails. It resulted in the release of nearly 40,000 under trial prisoners languishing in Bihar jails. In addition, there have been a series of cases wherein the court gave justice to the under trial prisoners and pronounced far-reaching judgments. For instance, in the case of Common Cause versus Union of India, the Supreme Court laid down that right to speedy trial is a part of Article 21 dealing with right to life, and thus the PIL activism addresses and confronts the power domination. Let me give you an example. In Bhagalpur, some police persons poured acid in the eyes of some suspects in their custody. As a result, the people lost their vision, and this case was reported by the media through what is now known as investigative journalism. The apex court took cognizance of that, and it is a classic case of how the police persons wielding power over the suspects held in their custody caused some atrocities on them, and in the end, justice was secured through the PIL process to the victims of police high-handedness and atrocities. It is in essence a movement to involve the judicial process for the creation of norms of a just social order based upon the principles of justice and humanism. Let me give you a contemporary example. For instance, the People's Union of Civil Liberties moved a case in the apex court on the right to food. They noticed that there were godowns stocking food grains and which were overflowing and which were being damaged by rats, and in the near vicinity of these godowns starvation deaths were occurring. And moved by this terrible and sordid episode, the People's Union for Civil Liberties, which is a non-governmental organization, knocked on the doors of the apex court, and the apex court gave a series of interim orders where it mentioned that food must be provided, in particular to the elderly, to the pregnant women, to the destitute women and children and lactating women and the disabled. So, and this case is still being taken up by the apex court, and the final orders are awaited, but it is an illustration of how PIL can serve the ends of a justice in an important area of economic, social, cultural rights such as the right to food. The public interest litigation has had a great impact on the rights of poor and the oppressed. If one examines the jurisprudence evolved by the Supreme Court of India, there are many instances. In case of D.K. Basu versus State of West Bengal, the apex court raised its voice against the custodial violence and laid down a series of do's and don'ts for government agencies and law enforcement personnel against torture. In the case of Vishaka versus State of Rajasthan, the Supreme Court laid down detailed rules on sexual harassment and laid down that mechanisms shall be created to handle sexual harassment at workplace. In other words, PIL has led to the emergence of new human rights such as right to speedy trial, right against torture, right against bondage, right against sexual harassment, right to shelter and housing, right to dignity, right to clean environment, right to education, right to legal aid, right to health care, and so on. PIL seeks to hold the government and its agencies within the leading strings of egalitarianism, humanism, and fairness, and correct by judicial admonition episodes of governmental lawlessness, excesses of power, or abuse of authority, or lapses. The foundations of public interest litigation in India were laid in the late 70s with cases like the Ratlam municipality case. If one looks at the history of the uh, Indian jurisprudence, the public interest litigation can be divided in three broad phases. The first phase of PIL started in the late 1970s and 1980s. In the first phase, the PIL cases were generally filed by public-spirited persons such as lawyers, journalists, social activists, or academics. Most of the cases related to the rights of disadvantaged sections of society such as child laborers, bonded laborers, prisoners, mentally challenged, pavement dwellers, and women. The relief was sought against the action or inaction on the part of the executive agencies, resulting in violations of fundamental rights under the Constitution. During this first phase, the judiciary responded by recognizing the rights of these people and giving directions to the government to redress the alleged violations. In the second phase, which involves the period of 1990s, several specialized NGOs and lawyers started bringing matters of public interest to the courts on a much regular basis. The issues covered ranged from protection of environment to corruption-free administration, right to education, sexual harassment at the workplace, relocation of industries, rule of law, good governance, and the general accountability of the government. The response of the judiciary during the second phase was by and large much bolder and unconventional than the first phase. The second phase was also the period when the misuse of PIL not only began but also reached to a disturbing level, which occasionally compelled the courts to impose fine for misusing PIL for private purposes. The third phase began with the 21st century. It further saw expansion of issues that could be raised as PIL. It's very important to note one feature in the third phase. In continuation of its approval of the government's policies of liberalization in Delhi Science Forum case, the judiciary has shown a general support to disinvestment and development policies of the government. If one looks at the history and evolution of PIL in India, one can see that it has achieved a number of things. It has secured justice to the persons belonging to the disadvantaged sections of society, enforced accountability of the executive, contributed to the good governance, among other things. Are there any pitfalls of PIL, or is it only purely a beneficial one? The answer is that there are a number of pitfalls of PIL. There are some who charge that courts are going beyond their normal role and are assuming extra constitutional powers. If one looks at the separation of powers as provided in the Constitution of India, a clear demarcation exists about the role of legislature, executive, and judiciary. And judiciary is not expected to encroach on the turf of the executive or vice versa. So the fear or concern in the executive about judicial overreach is a genuine one. PIL has the potential of involving political choices and imparting a political flavor to the judicial process. The close resemblance between the judicial function and legislative function in certain cases raises the troubling thought that such a congruency runs directly counter to the intent and scheme expressed in the Constitution. Though PIL has a number of beneficial effects, it's extremely important to ensure that it is not used to fulfill private interests, settle political scores, or gain easy publicity. The challenge for states, therefore, is to strike a balance in allowing legitimate PIL cases and discouraging frivolous ones. One way to achieve this balance could be to build in economic disincentives in PIL and also confine it primarily to those cases where access to justice is undermined by some kind of disability. So students, in this module, we have covered a basic introduction to the public interest litigation. We have also seen the constitutional basis for PIL and the important characteristics of PIL and the different phases in the evolution of PIL and its impact on the rights of the poor, marginalized and oppressed sections. To sum up, PIL led to the emergence of new human rights such as right to speedy trial, right against torture, right against bondage, right against sexual harassment, right to shelter and housing, right to dignity, right to clean environment, right to education, right to legal aid, right to health care, and so on and so forth. PIL marks a departure from the traditional adversarial judicial proceedings. The higher judiciary forged new remedies and fashioned new strategies designed to enforce fundamental rights. The Indian public interest litigation experience also shows us that it is critical to ensure that PIL does not become a facade to fulfill private interests, settle political scores, or gain easy publicity. Judiciary should not also use PIL as a device to run the country on a day-to-day basis or enter the legitimate domain of the executive and legislature. The challenge for states, therefore, is to strike a balance in allowing legitimate PIL cases and discouraging frivolous ones. Thank you.